Hello and welcome to Legally Speaking with me, Tarun Nangia. Today we commence the part 6 of our series on Justice Suryakant. The show is titled Justice Suryakant as Chief Justice of India Opportunities and Suggestions. I have someone who also has served in a long time at the Punjab Haryana High Court, was a Chief Justice of the Jammu and Kashmir High Court, but also served as the first president of the National Company Law Tribunal, or we could call him also the founder president of the National Company Law Tribunal. I would like to welcome Justice M. Kumar. Good to see you, sir. Thank you so much for your time. We have with us an advocate who practices at the Supreme Court of India, also at the Delhi High Court, also does arbitrations. In his past life, he was a chartered accountant, now a senior advocate. Senior advocate Percival Bilimoria. Good to see you, Mr. Bilimoria. Thank you for your time. Uh, at the outset, I want to request Justice Kumar to give his opening comment and suggestions and memories that he can share about Justice Suryakant.
Thank you, Tarun, for having me on the show. If I may say so, that to peep into the legal mind of a judge like Justice Suryakant, one need to go into the background from where he comes from. He is rooted in the masses and he adopts a realistic school of thought. I remember Justice Krishna Iyer used to say about picking up judges. He used to say that we should not appoint anyone who has not traveled in a local bus, because a lawyer who has traveled in the local bus, he knows what happens to the general public. He is close to the realities of life and can apply law more judiciously. This is what Justice Suryakant is. If you read Lord Denning adopted realistic theory of jurisprudence, not imperative law of school. So those who adopt, although he was disliked in England for his discarding imperative school of thought and adopting realistic school of thought, yet he is praised all over the Commonwealth. So a person like Justice Suryakant comes from that background. He always make effort that law must be on talking term with justice. How and why it can be done? If there is a will, thumb marked by an old person, old female, proved before the court, upheld by the district judge, two courts have decided in favor of the beneficiary. Matter comes to the High Court. Person like judge like Justice Suryakant may turn it over for the reason that the representation made to the lady was that it was 20-year lease, and under the garb of execution of lease, a will was got executed. Person like Justice Suryakant would apply the principle of non est factum, which he in fact has in few cases by deciding in Punjab and Haryana High Court, breaking away from the precedent that district judge is the final court of fact. Under section 100 CPC, the district judge is considered to be the final court of fact. But when he applied the law, an infirm, old, who has weak eyesight, sick lady who was willing to execute lease deed for 20 acres of land for 20 years ended up executing a will in favor of the beneficiary. When the matter traveled to the Supreme Court upheld. So this is the realistic theory which works at the mind, at the background of the mind of judges like Justice Suryakant. This is what I believe because we have rubbed shoulder together and I had a chance of giving audience as well as sitting with Justice Suryakant. So as far as I can see, he is a man of realistic school of thought, a real justice. Instead of doing justice in letter, not by letter, he would be, and you have seen in the registry right from the day one, the mentioning part and all that, the impression going out that influential people can have their say, priority in listing, etc. Those he from the day one, he gave a very loud message. The second thing which I think I would like to highlight, Justice Suryakant, as a CGI, has made a statement that there is a necessity to bring uniformity in law so that all the high courts may follow one principle, one law, instead of having conflicting opinion. It is inspired, if I may say so, by the American jurisprudence, which is known as the restatement of laws, uh, which is a set of treatises on legal subjects. It put together various precedents, professors of law, practicing attorneys, judges, all sit together, and there is American Legal Society. Under the aegis of American Legal Society, all of them work. And they try to state the principles of law so that judges, while deciding cases, attorney, while arguing cases, may be persuaded. It is not binding. It is only a guidance given to the lawyer, judges, professors, clarifying that this is a principle of law which is widely accepted and should be applied. As far as the legislation is concerned, everybody knows legislation, pure law, everybody can read it. But the differences come when the precedent are laid down. One lawyer would like to argue in one fashion, the other would like to argue in another fashion. Therefore, in order to avoid this conflict, I think a very pragmatic statement has been made by Justice Suryakant as a CGI that we should bring uniformity and probably this, in fact, if I remember correctly, maybe 15 years ago, a project by Supreme Court was started and our Attorney General was asked to write one subject, contempt of court. He had written one book on contempt of court. I think Justice Ravindran was in charge. Uh, if this project is taken up by the present CGI, I think it will go a long way to serve the cause of judiciary and in guiding high courts, district court, and the all the courts, in fact, even Supreme Court, that these are persuasive principles, not that anybody is stopped from arguing otherwise, but is stated in the treatises which are likely to be taken up, which are likely to be recorded. So this, I think, project is very, very important. If during his tenure this project is taken up, I think the second suggestion I would say that there are cases which go on for days after days after days. I think some system in coordination with the bars need to be developed so that there is some rationing of time and more time is devoted to the uh, uh, cases, because if you have a look into the English system, the QC, the senior advocates, they first change their notes, narrow down the differences, and on the question which is arguable, only on that question the arguments are advanced. This is the maturity of the bar, which comes on account of large, huge experience, which we are also developing, and I think in the times to come, if this can be taken up. The third suggestion which I would like to make is the press. You see, when bench is discussing the matter with the council, some observation is bound to come. And that observation is always an expression of seeking removal of doubts. That is not any final opinion being expressed. But the newspapers start reporting it as if it is the final opinion. They start debating in the press. In the Times report, I'm sure my friend Percy must have seen Times report, they report the judgment which are finally given. The matter is under consideration. Arguments are going on. Observation made by the judge cannot be the statement of law, cannot be decision of the case. So I think uh, some interaction on that score is required, and if that can be achieved, I think it will be a step forward to avoid any misleading. Now, for example, the Chief Justice of India made a statement that the National Judicial Commission matter has come, he will consider. In certain parts of the press and social media, what people have started saying, he will bring National Judicial Commission. That is, you see, extending it beyond comprehension. If it could be avoided, I think uh, I can request our Chief Justice of India that if something could be done by educating, not by, you see, by any other method, it has to be method of education only, because press is very mature in this country. I'm sure person like Kuldeep Nayyar, we have seen his book on supersession of judges and Indo-Pak relations between the lines and uh, distant neighbors, all those books. I think if we have journalists of that maturity, I think something can be achieved and constructive uh, criticism, constructive role of the Supreme Court can come forward. And also, I would say the bar has to be guided properly. This election based bar, I think there has to be some rethinking about it. The election based bar, I mean, the this type of standard which we expect, if those standards can be achieved, I think it would be a great achievement. And I look forward to the healthy tenure of the present Chief Justice of India, Justice Suryakant, and I wish him very well.
Thank you for such thoughtful suggestions that you gave, and also some memories that you shared of Justice Suryakant. Indeed, very anecdotal also. I'll go to Senior Advocate Percival Bilimoria for his opening comment and suggestions.
Thank you, Tarun. We've had some pearls of wisdom from Justice Kumar, and high praise indeed for the incoming Chief Justice. And you know that I value Justice Kumar's opinion a lot, and I share a lot of that also. I'm not going to talk about. I mean, I think by now, everyone knows some of the big decisions. The Justice, the incoming Chief Justice has played a role in, Pegasus and all that. I think we have to look forward. And in looking forward, the first thing is that, I think it's after quite a while that we have somebody who's going to be Chief Justice for about 14 months, I think.
Yes.
And, that means that he has the opportunity to shape or reshape the Supreme Court. And I think, from whatever I have gauged about the incoming Chief Justice, I don't think he will let go of that opportunity. And I think Justice Kumar touched upon some of the issues and the changes that could be thought about and contemplated. We also know, of course, that he's a big champion of mediation, and which is one of the main tools, I suppose, to reduce pendency. And if something can be settled, uh, like the Americans say, if you want to settle something, just forget about the money and get on with life and business. I mean, you don't have to keep quarreling all the time in court. And that's a very business oriented approach. And that's why I do believe that mediation has a very good future in this country. So that's a few things. I think I respectfully disagree with Justice Kumar. I do not believe that our press is very mature at this juncture. And in fact, one of the reasons why I say that is exactly what Justice Kumar raised, which is the undue speculation about NJC and things like that. I mean, somebody says something, and then it is blown out of proportion. And the I think the very very big point that was made, sir, is about what conversation is carried on in court being misconstrued. It can only be to the detriment of the system. And I've recently seen instances of this. So, for example, you know that there is a very heated issue on the dog matter, that is going on in court, and there are many who believe today that the Supreme Court is against dogs or against feeding of dogs. I do not subscribe to that view, right? Because if you read the order carefully, it contemplates feeding. But then, what has happened is that there are sections in our society who have started attacking feeders. Most of them are young girls, and they are just caregivers, and they are being attacked because under the notion that, oh, even the Supreme Court now frowns upon feeding. So, these kind of nebulous takeaways that people gather from what is reported or misreported, I would rather say, does create a lot of damage in society. I don't think it's a very good thing, and it can sometimes get out of hand.
Point very well taken, and good things. Any one suggestion that you would like to give?
Yeah, I think the pendency of cases, of course, a very very big issue, and I think in his somewhat longish tenure, I'm quite sure that he will see to it. What it's not just about more judges; it's about more very good judges. It's not quantity, but rather quantity and quality both. And I think maybe in that context, you know, some people maybe they were hoping that NJC would kind of enable that floodgates to open and more judges being elevated. But one doesn't know, and I don't think it's right to even speculate, as Justice Kumar pointed out. But I think it's time that we graduated to, and I think Justice Kumar made that point, which is a fixed time. I mean, it's impossible to say that all cases must be heard in X amount of time, right? Because each case will differ. It'll differ on whether it's fact heavy or not. There are many issues, but I think there could be some kind of precursor. Somebody appraises the case and says that, okay, I do not believe that this should take more than half an hour. There are only 2-3 points, and this is all that you have to focus on. The rest is not really controversial. It's not really in dispute. Even it may be, some of it may already have been admitted during the course of the proceedings. So fixed time. Uh, People. I think lawyers would love. I would certainly love a situation where I'm told that your case will be taken up at 11 o'clock. So in High Court, we are constantly pushing that could you please have a fixed time matter, please keep it at 2:30, etc. Because it enables predictability, it enables us to plan. And I think if the judiciary now, the whole system, if it just moves towards an appointed time where you're given a finite amount of time to argue your case and then move on to the next one, I think that's the only way that we can get rid of pendency.
Point very well. Some good points made. Thank you, Senior Advocate Percival Bilimoria. Now we move on to the final section. Any good wishes for Justice Suryakant, Justice M.M. Kumar?
Tarun, one thing which I would like to mention, because my dear friend just Mr. Percy have mentioned about mediation. You see, government states is the biggest litigant before the courts, Supreme Court, High Courts, and the appeals are preferred without there being any sound reason. On account of insecurity amongst the officers who is to recommend whether it is a fit case for appeal. For that purpose, one litigation policy was framed by the Union government in 2008. It is reported in SCC. In that litigation policy, in order to avoid fixing responsibility of a person, a committee was constituted of 5 persons: Advocate General, Chief Secretary, Secretary of the department concerned, some eminent member of the bar. So that committee would decide, because if the single judge has decided a case, placing reliance on the judgment of the Supreme Court, which is absolutely clear, where is the room for filing a letter of patent appeal before the two judges? Or after the LPA has been decided based on the laws propounded by Supreme Court, there is no room. Day in and day out, we see honorable judges of the Supreme Court condemning the filing of appeals, such like frivolous appeals. Section 11(6) appeal under the Arbitration Act, I saw in the Supreme Court, one of the benches said that if you in future file such appeal, we will dismisses with heavy cost and strictures. So those type of things would come to an end if that litigation policy framed in 2008 has gone somewhere. I don't know, do not know. It worked for some time. When I was a judge in Punjab and Haryana High Court, I saw it happening, but then it disappeared. So my one suggestion would be that if it could be, because the state is the biggest litigant, if it could be something like that can be revived, it will help in reduction of pendency, as my friend Percy was mentioning. I think somebody, CGI, can take it up, and it can help. I place on record my good wishes and very happy tenure, healthy tenure, a memorable historical tenure to Honorable Justice Suryakant, the CGI, and I am sure he will leave an impact for ages to remember.
Thank you, thank you, thank you for those good wishes. I'll go to Senior Advocate Percival Villimoria for his good wishes for Justice Suryakant.
Well, I'm certainly looking forward to Justice Suryakant's tenure at the hem, and I think he will definitely make an impact, and we all look forward to that.
We are all sure that his will be a very memorable tenure and a lot would be achieved. I would like to thank Justice M.M. Kumar for finding time for this show, and Senior Advocate Percival Villimoria for joining us today. Appreciate your joining us. Thank you so very much.
Thank
Thank
you.
you, sir.
For more such videos, subscribe to the Newsx YouTube channel, hit the bell icon.